Welcome back, everyone. We're glad you made it to the YouTube channel. I'm Rob Nuddleman, employment attorney, mediator, and public speaker. Today, we're going to talk about leaves of absences and how do we navigate those. So grab a cup of coffee. Let's dig in. I often get employers and employees asking about leaves of absences and what can an employer do? What should an employee do? Which leaves apply? And so it's a pretty common area for people to make mistakes or to have questions. So I thought it'd be helpful if I just did a little brief overview of some of the different laws that can and do apply when somebody needs to take time off of work for medical reasons, whether it's their own or family members. Keep in mind which laws apply will depend on the number of employees that you have. And for today, I'm talking specifically about California laws. There are federal laws that will apply, and we'll talk about that a little bit. But for the most part, I'm focusing on what California employers and California employees need to know about leave laws. What are the different laws that can apply? Well, first of all, every California employer is required to provide paid sick leave. Paid sick leave, if you just go with the state minimum, is a minimum of 5 days or 40 hours per year. There's two different ways to do it. You can do the lump sum method, you can do the accrual method, but basically, an employee can take up to 5 days for their own sickness or family member sickness. They now can also use paid sick leave for jury duty or witness leave if they need to take time off of work because either they are a victim of certain domestic violence or other crimes, or a family member is a victim and they need to take time off for treatment or to attend court appearances, etc. Those can all be covered by paid sick leave. And again, every single employer, as soon as you have one employee, must provide that paid sick leave. Once you have 5 or more employees, you are also going to be covered by the California Family Rights Act, as well as the Fair Employment and Housing Act's disability accommodation laws. Both those laws interact with one another, but they are distinct. The CFRA and FAMLA allow employees to take up to 12 weeks of unpaid time off for a serious or chronic medical condition. That can be their own serious or chronic medical condition, or it can be a family member's serious or chronic medical condition. A serious or chronic medical condition is fairly low threshold. It requires you to be under the care of a doctor or healthcare practitioner and to miss, I believe it's 3 or more days of work. The leave usually does not need to be taken all at once. It can be taken intermittently. So maybe I need to take a week off here or 2 weeks there or a day here or there for a doctor's appointment or a medical appointment. Then I can use that CFRA leave. There are certain limitations. To qualify for CFRA leave, I have to have worked with the company for at least 1 year, and I have to work at least 1,250 hours in the 12 months before I take the time off of work. I mentioned the FAMLA and CFRA, FAMLA being the federal law and CFRA being the state law, are similar. The big difference between the two comes with pregnancy leave. Once you have 5 employees, in addition to the disability leave as an accommodation, you also are required to provide time off for pregnancy disability leave. That can be up to 19 and a half weeks. We just say 4 months, where the employee is disabled as a result of pregnancy. So it only applies if you're pregnant, and it only applies when you're disabled as a result of pregnancy. And usually that's going to be dictated by when the doctor indicates that you can no longer perform your job with or without accommodations, or the doctor recommends you take time off of work. That may be for a period of time before the child is born. It might be for a period of time after the child is born. Generally speaking, doctors may give more or less time depending on if you had a cesarean or a vaginal birth or if there were other complications. And women are entitled to the pregnancy disability leave anytime they're disabled as a result of pregnancy, including for postpartum depression. Employees are entitled to up to 4 months, as I mentioned, of this pregnancy disability leave. And the difference with the California Family Rights Act and Family Medical Leave Act has to do with pregnancy disability leave. The Family Medical Leave Act, the federal version, which only applies if you have 50 or more employees working within a 75-mile radius of you. FAMLA does not run concurrently. FAMLA runs concurrently with the pregnancy disability leave. FAMLA runs concurrently with the pregnancy disability leave. So the 12 weeks of FMLA leave and pregnancy leave, pregnancy disability leave, run at the same time. The California Family Rights Act specifically does not run at the same time as a pregnancy disability leave. So an employee could take 4 months of pregnancy disability leave and then take an additional 12 weeks of bonding leave, because both the Family Medical Leave Act and the California Family Rights Act allow an employee to use up to 12 weeks of their CFRA leave to bond with a newborn or newly adopted child. They must use that bonding leave within 1 year of the birth or adoption of the child. Many employees and sometimes employers confuse paid family leave with bonding leave because they're used for the same thing, but they really mean two different things. The bonding leave under CFRA or under FAMLA is a job protection statute. You are entitled to take the time off of work, and as long as you're able to return to your work, then your employer has to guarantee your job. It is specifically unpaid under the law, although you may use your available paid sick leave. You can use available paid time off or vacation time, and many employers supplement or pay an employee while they're out on that bonding leave. Separately, the employee may be entitled to file for a version of state disability benefits called paid family leave. The Employment Development Department administers paid family leave, and it allows the employee to have a source of income while the employee is unable to work because they're bonding with the child. They can also use it while they're out on pregnancy leave or other types of medical leave. It doesn't pay 100% of your wages, which is why some employers choose to supplement that. And in some cities, such as San Francisco, an employer is obligated to supplement the paid family leave in certain circumstances. What if somebody exhausts those available leaves, or if those don't apply? Maybe the employee has a medical condition that impacts their ability to perform their job temporarily, and they need to take some time off of work. Both under the Federal Americans with Disabilities Act and the California Fair Employment and Housing Act, employers are required to provide reasonable accommodations to persons who are unable to perform the essential functions of the job. And sometimes that accommodation may be a temporary leave of absence. One of the difficulties with navigating the disability accommodation leaves is the law does not say a specific amount of time is or is not reasonable. It is dependent on the circumstances. It depends on the job. Obviously, a shorter leave of absence is more likely to be reasonable than an extended leave of absence. If your doctor is saying you're unable to work for the next 5 years, a court is likely to indicate that that's not a reasonable leave of absence, versus if the doctor is suggesting you need 30 days or 45 days or even 60 days off, that is more likely than not going to be a reasonable leave of absence. And many times those leaves of absences get extended over periods of time. So you may start off with 2 months and then it gets extended for another month and then another month, depending on what your doctor recommends. Many employers and employees ask, well, how much time is too much time? It's really difficult because it's pretty fact specific. There are always arguments about whether or not any requested accommodation creates an undue hardship. That's a pretty high standard and difficult to establish. And that's different than whether or not the leave itself is a reasonable accommodation. I know there are some cases that say a 6-month leave of absence may be reasonable. I've seen some cases where a year leave of absence has been unreasonable. I've seen some that have said a 9-month leave of absence is unreasonable because it really depends on the circumstances. So the idea is we really want to work with the employer and the employee together in this interactive process. And we're going to talk about reasonable accommodations, how to navigate that process in another episode. It is a topic in and of itself and probably could do 2 or 3 topics or 2 or 3 episodes on just that topic. So what about benefits during these leaves? The California Family Rights Act, Family Medical Leave Act, and Pregnancy Disability Leave Act all require the employer to continue the employee's health insurance as though the employee was still working during that time. So if the employer pays 100% of the health benefits normally, then during that leave of absence, whether it's pregnancy, disability leave, CFRA/FAMLA, the employer has to continue providing those health benefits and paying 100%. If the employee was responsible for 50%, then the employee can still be responsible for that 50%. Keeping in mind, you're going to have to make arrangements because normally the health benefits, the employee portion, is deducted from the employee's wages. Since they're not earning any wages, the employee may need to mail in a check or figure out a way to otherwise make their portion of the health insurance benefits while they're on that leave. That Pregnancy Disability Leave, Family Medical Leave Act, and California Family Rights Act are somewhat unique in that they are for specific periods of time and they are job guarantees. That means the employer has to put the employee back into that position at the same pay, at the same schedule, unless the employer could prove that the employee would have lost their job or lost that position, regardless of whether they went on the leave. So, for example, if I start a medical leave on April 1st and I'm not going to be back until June, but in May, the company has a company-wide layoff and the company can show that I was going to lose my job anyways, that my position has been eliminated, the company can proceed with that. Of course, it is somewhat risky. So obviously employers work with attorneys to ensure that, at least they should work with attorneys to ensure that they are not violating any laws by choosing one employee over another for a layoff. If your leave of absence extends beyond that CIFR or the pregnancy disability leave or some other leave that guarantees your job back, sometimes that job may still go away if you're out on that other type of disability leave. Regardless of whether it's for FAMLA or CIFRA or a disability leave, we do want to make our efforts to return an employee back to their same position if possible. If that's not, we want to look at other open and available positions that the employee is qualified for and try to put them into that one of those positions, assuming, of course, the employee wants to move into one of those positions. Another type of leave that I have not talked about is workers' compensation leave. I don't practice workers' compensation law. I know a lot of wonderful practitioners that do, but I know enough about it. Essentially, if you have suffered a workplace injury, there is insurance that will cover you. Every employer with even a single employee must have workers' compensation insurance. And employees may be allowed to take time off of work as a result of that industrial injury. How much time off? Again, there is no limit or anything that says this is the maximum amount of time that you can have off under the workers' compensation. My general rule of thumb is if an employee is out on an industrial injury, we don't terminate that employee. We keep them employed until they're ready to return to work. And then we evaluate whether they can come back to the same position. Do they need some other modified position? Now, those other leave laws that we talked about, the Family Medical Leave Act, Paid Sick Leave, Family Medical Leave Act, may all run concurrently with the workers' comp leave. So I get injured on the job. As a result, let's say I've shattered my leg and I'm not able to walk. And so I'm not able to come into work. Well, I can use my paid sick leave. I can use workers' comp leave. I can use the California Family Rights Act and or the Family Medical Leave Act, assuming I've been there for at least a year. and work the 1,250 hours. The employer is going to continue my health benefits, certainly during that period of time. Once the CIFRA and or family leave is exhausted, the health benefits may stop, and I may be responsible for 100% of my own benefits once that family and CIFRA leave has ended. If I'm not able to make the payments on the health benefits, then the health benefits will stop unless the employer is kind enough to continue paying that on my behalf, possibly under the agreement that I'm going to repay that to the employer when I return to work. There are other leaves that we have not gotten into detail about, we haven't really talked about. For certain employers, there's bone marrow and organ donor leave, where employees are entitled to a certain amount of paid time off for that. Jury duty and witness leave, employers have to allow employees to take time off of work for jury duty and witness leave. Typically, it does not have to be paid. However, employees can now choose, as of 2026, to use their available paid sick leave for jury duty and or for witness duty leave. Another leave that is oftentimes we don't come across too often, but can create confusion is military leave. The USERRA laws, USERRA laws, as well as California military leave laws, require employers of any size to provide time off of work to employees who are on active duty or who need to report for their reservist duty, etc. Under the USERRA law, when an employee returns back to work, not only are we required to return them to work after serving in the military, any promotions that they would have received and any raises that they would have received that are based on longevity of employment, we have to give those same promotions and raises as though they were working. Let's assume I'm an employer and I do a 5% cost of living increase across the board for all my employees. When you left, you were earning X dollars. I would apply that same cost of living increase to give you that same rate of pay that you would have earned had you continued working throughout that time. That way, we ease that transition to our men and women in the service to make it as easy as possible for them to be able to perform their military duty as well as be able to return back to the workforce. Another question that oftentimes come up is, what information can I ask of the employee regarding their condition, and what is an employee required to disclose to their employer? Employers are never allowed to ask what the diagnosis is or what the prognosis is. The employer can ask how the medical condition impacts the employee's ability to perform the job. The employer can ask what types of things the employer can do to help enable the employee to perform their job, but they should not be asking, hey, what is your medical condition? The question should be, how is your medical condition impacting your ability to perform one or more essential functions of the job? Employees are not obligated to disclose what their exact medical condition is. Sometimes that can be helpful, but that is entirely the employee's decision. Employees have the right to maintain privacy within their medical information. Employers, if they do receive any medical information, that information should be kept separate from the regular personnel file. There should be a separate medical file, whether it's electronic or otherwise, and it should be protected so that not everybody can have access to that. Employers should not disclose information about employee medical conditions beyond those that have an actual need to know about those medical conditions. So can an employer require an employee to provide a medical note when they're sick? Yes and no. The labor commissioner has taken the position that if an employee is sick and needs to take time off of work and use their available paid sick leave, then the employer cannot require the employee to provide a doctor's note. Requiring the employee to provide the doctor's note, according to the labor commissioner, interferes with their ability to take the paid sick leave. So my rule of thumb is, if the employee has available paid sick leave, we don't ask for a doctor's note. once the employee has exhausted their available paid sick leave, then we do ask for a doctor's note. Certainly for disability accommodation, pregnancy disability leave, SIFRA and or family leave, we want a doctor's note. There are specific certifications both under California and or under federal law for SIFRA and FMLA leave that the employer can use as a standard form and to get that information. I like using forms that are already created by the government because we know that those forms are not going to ask for information that we're not entitled to receive. Going through that accommodation process, if somebody has a disability and needs additional leave, can require getting some additional information from the doctors, but again, we're going to be limited because we cannot ask for a specific diagnosis or prognosis. So that's a lot of information about a lot of different leaves. Hopefully, it's just a little primer to let people understand what types of leave may interact, may apply, what ones do we need to know about. Hopefully, employer handbooks have these leaves listed. There are various posters that employers should have in the workplace that talk about these leaves. There's a lot of gray areas, a lot of different areas that employers can make mistakes. And it's important that employees understand what leaves they're entitled to so that they know what kind of job protections they do or they don't have. As always, if you have questions, feel free to put them in the comments. Feel free to reach out to me. I really enjoy doing employment law. I help employers and employees navigate these kind of very difficult situations sometimes and figure out how to do them. It can be very rewarding to ensure that there's a safe and harmonious workplace. So I really appreciate opportunities to have these conversations. So if you have questions, feel free to reach out. If you're enjoying the podcast, please hit the like button. It really helps. Subscribe, tell a friend, have somebody join the conversation. If there are specific topics you want me to cover, if there's guests you want me to have on, let me know. I'm always happy to do that. So long. Have a wonderful day.